Generally speaking, from your perspective, what do you think has been the biggest change in how the pretrial system operated before the Pretrial Fairness Act and now, after now that it's been implemented?
So for us, from the public defender perspective, previously we were not appointed until at the bond hearing. So when bond was set, if the defendant made the request for the public defender, only at that point were we appointed. The Pretrial Fairness Act changed to where we are appointed prior to their detention hearings. So it's created a little bit more work for us, but it gets us in their cases much quicker, and we're able to then have a voice at those detention hearings. Whereas previously at bond hearings, we were not appointed yet. We did not have a voice. We were not there advocating for what the client's bond should be set at.
I'm not used to going before the state's attorney. I also feel like I'm in a room with my Twitter feed. This is very strange. It's like my Twitter feed in real life. I suspect, I was talking to my wife about this answer, and I suspect that none of you all will believe me. But the timing, the way it is, I was in a meeting with our team around the statewide defense proposals, and I got a call from my cousin's girlfriend who let me know that my cousin had been arrested in Texas. And this, for the next 10 hours, I spent the good bit of the day trying to figure out how we could, get ransom money together to send down to Texas, all right? And there are these horrible conversations that you have about people selling whatever they can, all right? Whatever's not nailed down to pay a bond amount. So I think for lawyers, there's certainly one perspective of how the system has changed, right? It's very technical and we can talk about it. But I think for like families of accused people, I'm like super proud that I was a part of like 1,000 people who have tried in Illinois to stop like what I really think is like the psychological harm of trying to get like thousands of dollars together to bail your loved one out. Like there is certainly stories about accountability to be told in this system. There's stories about the need for pretrial incarceration. Like that is certainly people will have different opinions about that. But I think the eradication of money bond and the new system, I think like ends a system, or at least slows down a system that created lots of psychological harm on mainly black families, mainly poor black families in the state.
Thank you, Public Defender Mitchell.
Good morning. I think that to go a little bit to go broader, and the way that Defender Mitchell talked about the impact on the families, I want to talk at that same sort of broader level rather than sort of numbers. What I see on a daily basis is intentionality. I see transparency. I see prosecutors and victims and police, and not as much the defense attorneys at that detention moment, right? That moment where we're making a decision about whether to file a detention petition to be completely different than anything that's ever happened before in a good way. I'm involved. I see the dozens of decisions that our office makes about whether to engage in detention. For those of you who don't do this every day, you have to understand how different that is. Whether we are looking at it from the perspective of telling a victim what's going to happen, whether we are looking at it from the perspective of talking to the media, whether we are looking at it from the perspective of talking to the police, the intentionality that a prosecutor's office can have and the transparency that the entire system has to have is completely different. And I'm guessing that I'm probably going to come back to this point as we talk, but to understand that a judge and a prosecutor, the government, not Sharone's team, but that the government and the courts have to be intentional about their decision. It cannot and it is working this way, that we are talking about the reason we're making the decisions, including our detention petition. For those of you who don't remember, only the prosecutor's office can trigger the detention petition. And that's a conversation between lawyers now, between maybe advocates with police. Folks, that is entirely different. That is entirely different than the cash system. The cash system, the number was given by a judge based on a market, based on what she or he had seen from their colleagues, what they had done moments before. It was simply a number. And the intentionality on this detention point is making us a better and fairer system, and it is safer for victims because we can tell them we are filing a detention petition or we're not filing a detention petition. And how else should a government be held accountable other than to say what it is doing? Because when you simply say, well, we're going to ask, for a cash bond, or we're going to ask for a high cash bond, that is a moment of slippage, in my opinion, when it comes to government accountability. And what I've just described makes people uncomfortable. It makes judges and prosecutors uncomfortable because they're not used to that. They're used to throwing the case and the human being, right, the families, into that market of, well, let's just see how much money there is. This is very different and very good.
Yeah, and just to add to what Eric is saying, now we have, everybody has a right to appeal their detention hearing, whether they've been detained in the local jail or released on conditions. So, and that is a sea change in the appellate court. And I think we'll talk about that a little bit in a few minutes, but to Eric's point, a more transparent process. There's now a transcript that's being reviewed by the appellate court if the individual decides to appeal. And the importance of that is, and Charlene touched on this earlier, it creates a uniform body of law when you have appellate review, and it also is a check on the trial court to make sure that they are following the law. And this is extremely important given that this is brand new legislation and you want to make sure it's applied fairly in our 102 counties in Illinois.
Absolutely. Thank you for those answers. We're starting off already so rich with both personal experience and professional experience, and I really appreciate all that you have shared. So the next question is, do you think that the Pretrial Fairness Act is operating as community advocates and legislative champions intended? And if so, where and how are you seeing that?
I think for the most part it is. We are only 6 months in, right? We have how old are we going to say the cash system was? Are we going to, 1,000 years? Are we going to, we're 6 months in compared to many centuries of a system and a mentality that focused on money. And so there are many parts of it that are working. We are certainly, in Lake County at least, seeing the individuals that we would want to intentionally be detained, and we are seeing the individuals that are less dangerous, of course, not be detained. So from that perspective, it is working. I continue to, I continue to see it working. I continue to see we've put more resources into the prosecutor's office. We did have to hire a special victim specialist. Now that's just one person, so I guess I'll give it a number. That's a 10% increase, or maybe an 8% increase in victim specialists. I don't know whether the Cook County State's Attorney's Office has had to do that, but we haven't just been able to move things around. And I think I knew we weren't going to be able to do that, but we've actually put more victim specialists and prosecutors into this earlier time. And it really also, the system also acknowledges that this detention decision under the cash or under this new system was so monumental in a defendant's life. And if we're going to do something monumental in a defendant's life, maybe in a victim's life, we should be putting more resources into that anyway, right? And so it acknowledges how important this early decision is for both victims and defendants.
Yeah, I think it is also working as far as down in the county that I'm in. I think it is working as intended. I think it's actually working a little better than it was intended. Our numbers, and this isn't talked about a lot, but eventually I expect us to be hearing from sheriffs who are in charge of their jails on the difference this has made as far as their staffing issues and their inmate numbers. Mm-hmm. Our jail on September the 18th, the morning of that, we had 146 inmates in the Jackson County Jail. This morning we have 87. So that dramatic drop in itself is showing this is working. Our crime rate's not up. If anything, it's holding steady. It's actually probably even on the decline a little bit. I think it is working as intended. I think it's actually working better in my area than intended.
I think my answer probably is the product of me flying too close to the sun. But I think that there was like a kind of a theory or theme in the build up to this law coming in place, that this was like a rush job, and that this was like put together at the last second, and nobody had any idea what they were doing when it first started. When in reality, there was an intentional 2-year runway that was built into the law. Several trailer bills, and then a bonus 8 months. So we're talking about 2 years and 8 months, and maybe Cook County is unique, but there was so much work done in terms of implementation and trying to figure out how this would work. No law is perfect, no system is perfect. The Pretrial Fairness Act did not create crystal balls, but I would say that it is operating as it intended, because it is a more intentional, more structured system. And we see the things like State's Attorney Rinehart talked about, it's more predictability. To me, it maybe it's just because we've been working on it so hard, it is working like the expectation is on balance. Certainly there are a couple things happen individually that surprise you, but on balance, I think that things are working as intended.
The next question is, are you all seeing anything that would appear to be a departure from the legislative intent of the act? And if so, can you describe what that's looking like?
Yeah, with regard to repeals, the law has a presumption of release. Not everyone's going to be released. It's an individualized decision. But I think what's important is that that was the intent of the legislature. You have a presumption of release. And I can't say whether it's a departure per se, because we don't have the data. Keep in mind, people who appeal have chosen to do so. So my office, the State Appellate Defender, it's a self-selected group that we're receiving and what we're reviewing in terms of what we see is happening in the trial courts. So I can't really say, maybe Eric, I don't know if you could add in terms of like prosecutorial discretion or just how your trial judges are applying the law.
So the big change is sort of at that detention moment, that sort of intentional, investigated, thoughtful moment of whether we file a detention petition. I think that's going well, even better than expected, because our county board did give us the resources we needed. You never know if you're going to get the resources you need, and so from our perspective, that's going better. In terms of the departure from the legislative intent, I'm not sure if I'm seeing that. I think obviously the legislature can have a lot of different intents, particularly on something like this, where when we think about holding violent offenders without them being able to use cash, from my perspective, I think that's one of the good parts of this bail reform. On the other side, you have individuals who can't be held, and so you have different intent, right? You have different perspectives on why this is a good act, but the transparency in removing cash and the predictability are the sort of big directional reasons that I supported it. I can't think of a way right now that it's not moving as the legislature intended.
I think one of the things that I've seen kind of out in the landscape is this idea that you kind of have this runaway appellate system. And for me, that was a feature, not a bug. Like when before I became the public defender and when I was kind of on the lobbying side fighting for the bill, one of the things I talked about, especially with legislators that are lawyers, is that having an appellate process is actually incredibly important to this system. And that when we're talking about what I would rank the second biggest decision next to innocence or guilt, like whether somebody's going to be detained, that you want to have a vibrant appellate discussion, especially early on as you're defining what the law, how the law is going to be interpreted. So I have seen some stories to suggest like, oh my gosh, like there are all these appeals, what is going on? Maybe it's just me as a defense attorney. I'm like, yeah, that's what's supposed to happen. That's good. That not only are the decision making on the detention more transparent, and we're not hiding behind money, but we're also like evaluating like how the law should be interpreted through the appellate court. Like I'm happy to see like that's what I think the intent was.
Yeah, as far as our judges' decisions on the detention hearings, I'm not seeing too big of a departure other than, so when they decide to release someone and they can release them out on pretrial conditions, 9 times out of 10, that's just going to be the statutory conditions, and then occasionally they'll add extra conditions. But sometimes when they're ordering just, hey, here's your statutory conditions, you're out on pretrial release, the judge will still go ahead and order them reporting to pretrial services. And that seems a little bit superfluous. It seems extra. There's no real need for them to do that. They wouldn't have done that if this was under a money bond situation. They wouldn't be reporting to anybody pretrial anyway. So that's kind of the only departure that we're really seeing, is just that extra step of ordering them, when there's nothing extra for them to do, ordering them to keep reporting to pretrial services.
That's definitely an important concern to raise, because we know that the more requirements and restrictions that you put on accused people before a trial, the more that creates opportunities for people to then be accused of violations and potentially be reincarcerated. So that's an important thing that you flagged. Thank you for that.
I do think that the legislature maybe thought they gave more guidance to courts about the transition period in terms of the cases where you had individuals who were held on cash, how some of that converted. I do think that I don't think we have any legislators here. I guess I can talk to them later. I do think that they thought that was maybe going to be a little bit clearer than it was. I don't think that impacted safety. If anything, I think it may have impacted. I think that was a little bit complex, but now the courts have worked that out.
So another question is, are you seeing situations where court stakeholders are expressing resistance to the changes that come with the Pretrial Fairness Act? And if so, how are you seeing that affect implementation?
Well, I can only speak from the appellate court perspective, which we'll get into in a couple of minutes. And I have to thread the needle carefully, again, any appellate court judges here. It's a tremendous burden on them. I'll put it like that. And I think more so in the trial court, it's also a lot more for the judges to do, the prosecutors to do, and also the public defenders or private counsel if someone has that. So anything new, people don't like to start with. That's just how life is, and I think that's human nature. It's a sea change of how things were done, and you have a lot of judges, I think, well, we always did it this way. Some judges did not want to implement the law, but that's why we have a appellate review to correct any errors about that. But I mean, I think overall, whenever you introduce a new system, no matter if it has to do with criminal justice or what have you, there's always going to be some resistance, and to take some time for people to learn the new system and implement it in accordance to how it was designed.
The judge, in my opinion, the judges, and they've said this in public courtrooms, so these aren't private conversations. I mean, judges have literally said out loud, well, under the old system, I would hold you, but under the new system, I'm releasing you. I don't really know what that means. What they mean is, under the old system, I'd be temporarily holding you until somebody found cash. There's sort of this focus on the short, what I'll call from their perspective, the short-term hold. Well, I'm not comfortable holding you under detention under the current system, and so I want to have this moment of saying, well, I would have held you, but now I'm going to release you, and that's completely, in my opinion, ignoring the fact that they don't know how much money someone has. And so this statement that, well, under the old system I'd hold you, but now I have to release you, I don't know what any of that means. They were putting down monetary bonds. They don't know whether people can post that bond, and they think that the community is safe or unsafe. I don't know what their opinion is on that either. So the resistance I have seen from the judges is to, and I'm sorry, it does go back to my earlier point, to move this framework out of this is safer for me because I can do what I have always done. The resistance is, I don't want to make this binary decision of either you're in or you're out. It's what the law requires. It's great for safety. It's great for victims. And it's great for underserved communities where there isn't access to money. As hard as, I keep saying this, as hard as all of this is to decide who should be in or out, of course we should be focused on safety, 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 and not access to cash. because saying it's hard doesn't mean that the old system is better just because we were used to it, right? And so that's the resistance I'm seeing.
One thing under the old money bond system, your circuit clerk's office got to keep 10% of whatever money bond was posted. So the loudest of our court-based stakeholders down in my county has been our circuit clerk complaining constantly on how her funding has been cut when she's really just not getting to keep 10% of bonds because we don't have bonds anymore that are paid in cash. So the other thing I have seen, as this is an election year and I'm in a small county and there's a contested state's attorney's race, our state's attorney has, on at least one occasion, not filed to detain someone. Therefore, the judge could not hold them. And then the press release or the soundbite the state's attorney releases is how, well, he filed the charges because of Pretrial Fairness Act, this person couldn't be detained. So there's political spin, at least that I'm seeing put on it, which I take that as kind of being resistant to the changes with the Pretrial Fairness Act. Because otherwise the judge would have set bond under the old system, and the state's attorney, would have just had to go with what that bond was.
Thank you all for those comments. And yeah, State's Attorney Rinehart, the piece about just really acknowledging that under the old system, it was always a gamble. And I think the idea that it was anything more sure, that it was anything more sturdy, that it was anything that anybody should have more confidence in is definitely something worth reiterating, that that's just not the case. And I appreciate you pointing that out. It's one thing for there to be resistance expressed and, oh, well, I don't really like this law, but I'm applying it. And it's another thing for, those feelings about the law to actually impede proper implementation. So the next question is, are you seeing any trends that concern you about how some prosecutors or judges are thinking about detention decisions and, filing motions, setting conditions of pretrial release?
The trend that we're seeing is, as this has played out, the selective, maybe the first couple months it was more of we'll file on everything that's been, that's on that list of what's a forcible felony. We'll file our detention petitions on those. That's kind of been whittled down to now we're seeing the petitions to detain on the ones where it's most likely to be granted. It's much more, I think there's much more discernment going on from our prosecutors, knowing what the judge has ruled on previously, what they can expect to do. Because we have had, given a small county, we've had the same judge assigned to detention hearings since its implementation went into effect. So as his rulings have come down here and there, kind of knowing what conditions he's going to be looking for and who he's willing to detain, I think it's made the state's attorney much more selective on who they're filing to detain on.
Maybe I'll say this. I do worry about the politicization of detention decisions and, commitments to file on every type of case because we think that's going to get us votes, as opposed to taking the discretion that I think the rules of professional responsibility require us to do, to look at every case for its merits, as opposed to, just making declarations before you pick up a file that, in every case like this, we're going to file. I think that's a problematic trend.
Yeah, we have to look at it. We have to look at every case individually. I can literally see the work of my team doing that. I've made sure that I'm, that is being very well trained and very well resourced. That's what I said earlier. You have to resource that area so that there isn't a mistake by prosecutors in either direction. I haven't heard anything systemic in terms of the judges systemically getting it wrong. I mean, they seem to enjoy saying on non-detainable cases that I can't hold you anymore because of the Safety Act, but they're sort of giving an advisory opinion, which makes me want to call them and ask if they would tell me what their old cash bond would have been, since they're into advisory opinions. There's this tension at the beginning of this sort of attack on the Safety Act, which is, well, now it's under the Safety Act, sir, and I can't hold you on your first-time retail theft. they wouldn't have been held anyway. And so, there seems to be this politicization of of that front end decision. But I think our prosecutors are doing a great job.
The next question, and I'm specifically interested in hearing from Carolyn, from your kind of bird's eye view at the State Appellate Defender, as well as Celeste. What are unique challenges that you are seeing with implementing the law in more rural counties?
We are one of the counties that's under the Office of the Statewide Pretrial Services. So when they started, they gave us 2, and they are 2 of the most hardworking people that I have met. But we have 2 pretrial services officers. For a long time, they didn't even have a physical location. So they did not have an office to have clients go to when they were ordered to report to pretrial services. So that has been an issue, and it's an ongoing issue. They now have a physical location. However, we still just have the 2 pretrial service officers. They don't work past 3:30 in the afternoon. So one of our current issues that has come up repeatedly, because sometimes court goes past 3:30 in the afternoon, we've had the judge order client released with an ankle monitor to be on them, and pretrial services is closed. They can't get their monitor till the next day. That's terrible. There's no immediate remedy for that, but that's one of our biggest ones. The second biggest one, of course, is the availability of services. We're overwhelmingly dealing with the mental health crisis that's ongoing throughout the state. We don't have immediate access to mental health services. It's a struggle to get those. It's a struggle to get anyone to, if a person is detained, to have a mental health person come evaluate them that could then help potentially getting them released. With the Office of Pretrial Services closing at 3:30 in the afternoon, anyone who works banker's hours, it's a struggle for them to report to pretrial services. Now they're having to miss more work to make it to an appointment, whereas if their office just stayed open until 7, it would help us tremendously. Rural-wise, we're being a more rural county. It is the lack of the services. Transportation for us is always an issue. We have a mass transit system. It's not nearly the level that you'll see as far as mass transit in a city like Chicago. There are struggles that it comes with almost anything that a rural county would have. But really, pretrial services, that's kind of been our the biggest hurdle. We need more pretrial services officers assigned to our county. And we need them to have longer hours and be more accessible.
Thank you. And that also seems to raise the importance of what you shared about judges assigning people to pretrial services when it isn't necessary or doesn't seem necessary. And that seems like that might contribute to those systemic issues and should be addressed.
Just to adding what Celeste, mental health. We see transcripts where it's, a client who's mentally ill, he or she is in treatment or resistant to treatment and reoffends. And when I say reoffend, often maybe they're arguing with their parents who have tried to help them. And we had a decision this week where we have a judge saying on the record, I don't want to detain you, but there's no other option here because you're, calling your coworkers and saying you're going to plant a bomb at the factory you work at, and there's other issues going on. So it really illuminates the lack of mental health services we have in the state of Illinois and the need for them, the desperate need for them to keep people out of jails and actually, make their life better by ensuring that they get the mental health treatment that they need and deserve.
The mental health treatment is so important to this. And we need a New Deal level investment in mental health services in this state and in this country for so many reasons. The least of which, maybe some of these issues in the jails, right? Most importantly, it's our moral duty to invest in mental health services, and it makes not only those individuals healthy, but it also protects people. And so, with the Safety Act. Having the release of individuals on these lower level and these nonviolent offenses, it puts pressure earlier in the system or earlier after the arrest for services. And I think it's an important opportunity. It just has to be resourced correctly. It's an important opportunity for police to make direct community referrals instead of bringing them to the jail, because they no longer can bring them to jail on the trespassing. They can no longer bring them to jail on the disorderly conduct. They can arrest them, but they're not going to be held there while their case is pending, which I think means we need to actually connect our police departments. And I think we're doing a good job on this in Lake County. I may be able to put some resources into it very soon, but it puts more pressure on our health departments, maybe in, throughout the state. It puts more pressure on police to have that community connection to refer those services earlier. The jail wasn't the right reason either, but there was no referral pressure on a police department because they were making the referral to the sheriff.
I think that's a great point. I was going to bring that up. I think that sometimes folks use the jail as a mental health treatment facility, and you had folks talking about referring to jails as mental health treatment facilities or drug treatment facilities. And if you looked at the numbers and you looked at the outcomes, that certainly wasn't the case. You look at the description of what people were getting, that's certainly not the case. So I'm glad we have an opportunity now to be more transparent about community needs as opposed to hiding those needs under the guise of inappropriate pretrial incarceration.
Absolutely. Thank you all so much for raising the importance of services available in the community. I know that this entire summit is about the Pretrial Fairness Act, but it would be shameful to not mention right now the Pretrial Success Act, which is focused on, which is a bill right now that's in the legislature requesting $15 million in appropriations to ensure that there are services available in communities throughout the state, from mental health to substance use to transportation and childcare, things that often impede people from making it to court. That is up for consideration before the state legislature, and it's only a drop in the bucket, but it's an important start and step in that direction of making sure that people have the resources they need when they are given the opportunity to avoid pretrial incarceration. And so the next question is for Carolyn, and anyone can also comment on this. Since the Pretrial Fairness Act has been implemented, there has been a surge in appeals, specifically under the act. When a trial court makes a detention decision, either the state's attorney or the accused person can appeal it depending on the outcome. And that's an important aspect of the system that provides for a check on the judge's authority. So can you talk about how the appellate process is working? And Carolyn, when it comes to you, we'd love to hear you talk about some of the issues you've been seeing with appeals that have been filed.
Thank you. Just so we have a statewide appellate defender. It's called the Office of the State Appellate Defender. And what that is anyone who's convicted of a crime in the state of Illinois has a right to appeal. And the Pretrial Fairness Act then gave pretrial detention orders the right to appeal. So those came into our office. We have 101 counties that we deal with. Cook County, Sharone's office, does the Pretrial Fairness Act appeals out of Cook County. Also, and I don't want to bore everyone, I was excited someone asked about appeals. I mentioned to them, I said, there's no TV shows about appeals, no podcasts about appeals. But that you're interested, it makes me happy. But just for some context, our appellate court is divided into 5 different districts statewide. The first district is here in Cook County. And I think one thing that we've noticed in terms of the appellate process, so keep in mind, if someone appeals, we as the appellate attorney get the transcript from the detention hearing or the release if the client's released. And then what we do as an appellate attorney, and this is true for whether you've been convicted or a pretrial appeal, is we look to determine whether or not the judge's decision conforms with the law procedurally, in terms of, did the judge follow the right procedure? Did the state's attorney follow the right procedure? Did the defense attorney ensure that you had your Sixth Amendment right to counsel? There's also then whether or not the state has the burden of proving by clear and convincing evidence whether or not you meet the standard that you should be detained. So we can also argue that that is more of a factual argument. And in the appellate court, I would say that it's working well. The volume you've heard about a few times today has been exponential. I think if you have access, I would recommend that you look at the pretrial release task force report that came out, and Charlene can make it available, came out on March 1st. What that was, the Illinois Supreme Court convened a task force in February to sort of get a handle on the volume. And just for context, pre-September 18th, I think they were getting about 17 appeals per year for pretrial, and To date, they've had 4,500 since September 18th. So it's a lot. It's a lot on the system. My office and the state appellate prosecutor asked and received a $20 million expenditure to cover this because we anticipated the volume. The appellate court, I can't speak for them. They had to deal with this increased number of appeals. And keep in mind, for case management, just some perspective, when they have to put a case into their system, no matter what kind of appeal it is, civil appeal, a post-conviction appeal, a PFA appeal, that takes time to get it merely in their computer system. And then you have a certain amount of judges who have to review the decision. But like we mentioned previously, the importance is that the law is uniformly applied across the state. Because we had certain judges who, as Eric mentioned too, they didn't like the Pretrial Fairness Act. They said it on the record, which was nice for us because it was easy for us to then say, well, this judge already said she's not going to apply the law, so we got it reversed. But in terms of appellate review, the appellate courts, the first district appellate court, which is here in Cook County, we've noticed has been what we would consider more progressive in reversing detention decisions. And that could be based on procedural or factual based. And some of that may have to do with the fact that their volume has been exponentially less than the remaining 4 districts of the appellate court. So to some extent, and I know they said they've been plenty busy, they may have had more time to really look at these cases more closely, where our 2nd, 3rd, 4th, and especially the 4th and 5th district appellate courts have been swamped without additional resources. So the conditions or the issues we see on appeal often, like I mentioned, procedural issues, timing, did the state's attorney seek to detain, file their petition in time? It's the purpose is to make sure the law was applied. That's what it boils down to. One other thing that I should mention in terms of appeals is that we do need more published decisions. And the reason for that, the appellate court can issue what they call a published opinion. They can also issue what's called a Rule 23 order and something called a summary order, which other judges don't have to follow, or they don't actually see. And the more published decisions we get out of the appellate court statewide, the easier it'll be for Eric, Sharone, and Celeste to say to the judge before, Judge, the appellate court has said this is the procedure that we have to follow, this is how we do it, here's some case law on it, and then that will allow for a more equal system statewide. Because what we don't want is a certain judge in one county detaining everyone who commits an armed robbery, regardless, where we have other counties where it's a disparate treatment. So that's why it's important that we have appellate review to ensure that the law is applied and then it becomes uniform.
Can I ask a follow-up question to that?
Mm-hmm.
How often are we seeing the published opinions compared to the Rule 23 and summary orders?
Well, it's hard. The part of it is there's so many appeals that the appellate court, they can sort of issue a quick summary order. There's rules about, like I said, I won't turn this into a appellate practice and procedure seminar, or you might leave. But it's interesting. I'm happy to answer any questions about it. But in terms of published opinions, we haven't gotten too many published opinions. We've gotten a few that are published because they seem to want to air out their grievances about the volume. Because when we get an appeal, what we can do is we can, as the appellant, normally we file an appellate brief. In certain cases, we can file what's called a memo. It's just a different word for a brief. And there's now, which changes, some judges were not happy that we wouldn't file a memo in every case, and the reason we didn't need to do that is because the record speaks for itself. So did the notice of appeal, the issues raised, and there was really nothing for us to add. So I think it just takes time. And the appellate court, like any of the bodies that are involved in the court system, will have to, keep plugging along and hopefully start giving us more published decisions that we can then give to our trial attorneys and say, hey, this decision just came out. I think it'd be helpful on this issue.
Yeah, and can you briefly lift up what are some of the most common issues you're seeing coming up in the appeals?
The most, obviously, or I shouldn't say obviously, the most common issue is the conditions of release, what we're arguing usually on appeal. So keep in mind, 95% of the appeals that come into my office are for someone who has been detained. And there's about 5% that the prosecutor has appealed, and usually that is because the individual's been released. So what we're arguing mostly is whether or not there were some conditions that could have allowed for this release that is presumed to be a release. Could they have been on electronic monitoring? Could they have had a no contact order? Could there have been other conditions of release imposed? And often the problem is the judge at the trial hearing, or I'm sorry, the detention hearing isn't really articulating why he or she is deciding to detain the defendant. Often they'll say, based on the facts of the charge, and if it's a serious charge, they might just rely on the charge itself. We had a good decision out of the First District Appellate Court saying, no, you can't just rely on the charge, say it's an armed robbery. Otherwise, our legislature would have said, oh, everything is a presumption of release except armed robbery. And that's not how the law is. Every charge from first-degree murder on down, you do have a presumption of release. So the judge can't just base their decision about detention on the charge. So that's really probably the biggest issue. And then some procedural issues in terms of timing, what the judge is required to do. But releases, that's the conditions of release.
Thank you. And so you mentioned about how the Supreme Court formed the pretrial release task force and, released a number of changes in rules to try to address the dramatic increase in appellate cases. And so could you talk a little bit about some of the changes that were made and what you think their impact will be?
Right. So as I mentioned, there was a Pretrial Fairness Act task force that was convened by the Illinois Supreme Court. They issued a report, and there were changes to Rule 604H, which Carolyn mentioned at the beginning, which is what gives you the right to appeal. And what they did is before you would have your detention hearing and then you would file a notice of appeal. Now what they've done, one of the changes is that you now have to file a motion for relief before you can file a notice of appeal. And that type of document is not atypical in the trial court. If someone is convicted, there's typically a motion for new trial. Once there is a sentencing hearing, there's typically a motion to reconsider sentence. This sort of adds that component to the Pretrial Fairness Act detention hearings in the sense that they're giving the trial judge another opportunity to revisit the evidence that was presented at the detention hearing. If there was any error that was made by the judge, that could possibly be corrected at the trial level. And the reason that the task force did this and the rule was changed is, again, we're tracking back to the volume issue. It overwhelmed the appellate court. And keep in mind that the appellate court deals with criminal convictions, civil cases, child welfare, parental rights. So there's other extremely important issues in front of the appellate court that were getting pushed aside. Obviously, we think the Pretrial Fairness Act, our clients are presumed innocent. If they're in jail, that's a deprivation of their liberty. But the Supreme Court thought it was wise to add this component of the motion for relief before filing a notice of appeal to hopefully get the volume down a little. We certainly hope it doesn't put a chilling effect on people's right to appeal, because the Supreme Court can't actually remove that from the statute. That would have to be removed by the state legislature, which we certainly hope does not happen. But it's added more work for the trial attorney and also for the judge. In addition to that, they removed, before you had 14 days, so your detention hearings today, you had 14 days to file your notice of appeal, or you were too late until your next hearing. They removed that also with the understanding that maybe people will be more deliberate in determining when they want to appeal the detention decision, if at all. Maybe the client wants to appeal, but the trial attorney might say, you know what, let's get more evidence to advocate for your release, and we'll bring that to the judge, and then when we do that, we might have a better opportunity to have you released from pretrial detention. The appellate court also gave itself an additional time to consider these cases. So the biggest change, we do hope, while the intent of these changes was to limit the number of appeals, we do not want it to have a chilling effect on appeals. And having said that, the flip side of that is, if the volume goes down, then the cases that are before the appellate court will hopefully get more attention from the court itself because they're not overwhelmed by this volume. So there's two sides to this coin, because we want to make sure that our cases and our clients are getting meaningful appellate review. And with the tremendous volume, that was hard to say that was possible for all of our clients on appeal.
Thank you. And to confirm, is it too early to say what the effect of these rules have been in terms of like affecting the volume? These just went into effect this month, right?
Yeah, so this started April 15th. Just for context, I can tell you, and this was as of Wednesday or yesterday, so my office in 2 weeks' time had gotten 26 appeals. So if we extrapolate that out for 1 month, that would be 50. Just for context, in September we had 77, October we had 349, November 413, December 147, January 285, February 234, March 294, and now in April, the first 2 weeks, 26. So, but keep in mind, people were filing their notice of appeal before. They had to do it within 14 days if they were going to do it. Now they have to do this motion for relief as a condition precedent. They have to have a hearing on it. They have to have a ruling by the judge, and then they can file the notice of appeal. So our anticipation is that we do think the numbers will go down, but we think there will be this lull, which we're seeing right now, until the public defenders and the trial court get used, or private counsel, used to the new system. And like I said, they do. The attorneys are used to filing sort of these type of motions because they file motions for new trial and motions to reconsider sentence. So it's just very similar to that.
Next question is for Public Defender Sharone Mitchell, as well as State's Attorney Eric Rinehart. When the Pretrial Fairness Act went into effect, we saw not as many as we anticipated, but still some headlines blaming certain release decisions on the Pretrial Fairness Act. Sometimes the complaint would be that somebody was released when they were accused of a violent crime. Other times we would see stories where people were released and later accused of committing a new crime. And sometimes we would see language that said something to the effect of, this person was released under the Pretrial Fairness Act. Can you talk about what the problem is with that framing, which means, regardless of what somebody might think about the individual release decision, what are the problems with blaming the decisions wholesale on the new law?
This is a really important question. Everything that happens when it comes to release or detention in our criminal justice system from September 18th forward will be after the Safety Act. And I would call upon my friends in the press to think about that everything that happens after September 18th, 2023 going forward happens after the Safety Act, not because of the Safety Act. The entire framing of every decision that is about to happen in terms of the beginning of a criminal justice case will be happening after the Safety Act. But the problem with this framing is that there is no perspective from the past. So, for example, there was a DUI death case in a Collier County, not my Collier County, and not in Lake County. There was a DUI death case, a very serious case, and the prosecutor, in my opinion, from what I know, appropriately, though I don't know the facts of the case, but obviously you would think that a detention petition would be warranted when a DUI caused somebody's death. The judge denied the petition. The Safety Act was blamed. Obviously, the prosecutor did the right thing. I mean, for purposes of this conversation, for filing the detention petition, or from the perspective of the critics of the Safety Act, they would say, well, of course it was the right thing to file the detention petition, and then the judge denied it. What the story did not include was an analysis of how many defendants under the old system post cash on those types of cases. If you don't compare it to the past, if you don't compare it to what used to happen in terms of the number, from the perspective of those critics, that quote unquote too many people are being released, there's no perspective on how many people were posting bond on those serious cases. I had a case where our office was criticized for not filing the detention petition, and for this particular crime, the last 6 individuals had posted between $10,000 and $20,000 cash. And there was zero criticism in those years prior of a system that allowed those individuals to post cash. The problem that we have is that this is an important and monumental reform. It was a reform that people watched happen live. It happened in the legislature. And people need to have the perspective that the old system played out over 1,000 years. Lawyers and judges are comfortable thinking about things that happened over 1,000 years. But many of those lawyers and judges are white. Many of those lawyers and judges are men or from well-resourced communities. So when we think about things that happened over 1,000 years, I'm using that term very pointedly. There have been a lot of important changes, and there isn't enough change yet. But the fact is that that was a system that happened slowly, and it happened in a time of racism and sexism and every other type of ism you can think of. And this is a new day where we are seeing a system play out that is focusing on safety and not access to cash. But yeah, things are going to happen after the Safety Act, but that doesn't mean they happened because of the Safety Act. And when judges say, well, I have to release you under the Safety Act, they might as well say, I have to release you under the law that was democratically enacted. And the fact that we know all of the legislatures that were doing it because it's a modern reform doesn't make it less strong. It doesn't make it less principled. People feel like, well, this was decided, and I'm going to use the phrase intentionally here, well, this was decided by men in the 1950s, so it must be okay. What? What? That doesn't make any sense. And so a diverse legislature that worked on this for years and thought about this for years, developed this, and things are going to happen after the reform, but not in this way because of the reform. I'm sorry, that was a very long answer, but I feel very passionately that people need to frame this question correctly in history.
Thank you. Yeah, no, that's yeah. It's a mic drop. It is a mic drop. That's absolutely.
The defense rests.
Yeah, that's so true, and I'm so glad that you said that, especially for people from the media who are here and have interest in reporting out to the public about what's happening with implementation. It's so important to distinguish between what's happening after the law versus because of the law, and even headlines that might imply that it's happening because of the law, even if they're not necessarily making that claim based on facts.
I mean, judges are saying it. Judges didn't say under the old day, I'm setting your bond at $100,000 because of a system that was built 1,000 years ago. They didn't say it. If they said that, if they said, I'm setting your cash bond at $100,000 because we're using a wealth-based system, I mean, you can't make a judge say something, right, because of the separation of powers, which I believe in. But you can't make a judge say, well, I'm doing this because that's the way we've always done it for 1,000 years, next case. Think about how the public would react to that as opposed to what they're saying now. Well, I have to release you because of the Safety Act. Follow the law. It was democratically enacted by good, democratically elected people.
Briefly, just want to look forward to the future of pretrial justice in Illinois. We've talked about how there's been fear-mongering, sometimes from court actors themselves, sometimes in the media. And so generally, I'm going to kind of ask overall, like rapid fire, do you think that we should be concerned about rollbacks? Should we be concerned about how fear-mongering around this reform might be affecting the ability of other criminal legal system reforms to advance? So yeah, just want to throw that out there. And any comments before we open it up for questions?
I think there's a reason to be concerned, but certainly I think the successes that we've seen, I think, puts us at a different position than what people expected. There were predictions about the streets running red with blood and the purge happening. And congratulations to everybody for surviving the purge. But I think that definitely puts us in a little bit of a different position. Now, that's not to say that our communities aren't going through things, right? But I think oftentimes we ask for reforms to solve issues that existed both before or after the reform, and that to me doesn't seem incredibly fair. I think that what we've seen is that this is a far more responsible and serious approach to a really important question about whether someone should be detained before trial or not.
I would only add that in an era where we need more, you do very good with this in Chicago with crime data. You do very good to have crime data, but we should always be worried about rollbacks and people taking over the narrative through anecdotes as opposed to data. I think that the Safety Act comes out of a place of focusing on safety as opposed to cash. I think that's a big, correct, moral decision. But I think that people will always be able to say that, that this has happened or that has happened And I'm not saying that the data justifies the Safety Act in advance, but the data certainly shows after the fact that the bad things didn't happen, because every crime is something that we want to prevent. It's National Crime Victims' Rights Week, and it must be said that every major victims' rights group in the state of Illinois supported the Safety Act. That's one of the reasons that I support the Safety Act, is because they've lived in the trauma of a cash system, and they have more experience with it than I do, and so I listen to those advocates. But yes, I think every legislative session we should be worried about rollbacks.
I'd just like to add one thing to that too, since this is a media event. There, as Eric's point, the data, look to see, because this will happen, this just happened to the Illinois Prisoner Review Board. They look at mandatory supervised release decisions constantly. And there was a case recently in the news, which I'm sure you're all familiar with. It was mislabeled as being a parole release, which was incorrect. It was mandatory supervised release. That is a distinction that's important. But to Eric's point with data, Pretrial Fairness Act release, unfortunately, at some point, because this is human nature, there will be one case that will make the news, and it'll be horrific, but we would just ask that you put the numbers in context, that one person not be responsible for a rollback, because we trust the system to do what's right. We trust the judges, the prosecutors, the public defenders. We're not perfect, so when there is a problem, which will happen, we would just ask that you look at the data and look at the total context. The other thing I would say is look to New Jersey. This is modeled off the state of New Jersey. Their reform, cashless bail, has been in effect several years, and they had a report released last year that shows it's working, it's making communities safer, it's less disruptive to the people involved, and it overall is working as intended.
I think you were kind of referencing the DeKalb County case, and how the prosecutor filed that petition for detention. I guess, the general public, I feel like, believes that the judge should have granted detention in that case. How do you hold a judge accountable for the decisions that they're making in these, especially if, as was just mentioned, someday in the future, one of these people who was, the judge decided it was okay to be released, goes out and commits a new terrible crime?
We have three equal branches of government, and the idea about how to hold judges accountable is, probably beyond my ability to answer. My only pushback to you is judges were making decisions that impacted families that Defender Mitchell talked about for decades, for generations. Judges were making decisions that allowed truly dangerous people to post low cash and then go and potentially re-traumatize their victim. And so, unfortunately, we are in the space of dealing with, with crime and bad things happening. But judges' decisions are supposed to be based on the law. They're supposed to be based on their best judgment. Remember, a lot of this is. I do want to do a little bit of framing. I don't mean to get too meta, but a lot of this is a reply to a response, right? Even in the way the four of us are answering questions, even in some things Briana has said. The argument for the Safety Act, there's lots of good arguments for the Safety Act. I'm just going to put that over there. And then there is this political response, in my opinion, from people who were being extreme and irresponsible. And then the rest of us are kind of replying to that response, right? The arguments for the Safety Act, we've already made them. There's this response out there, and now we're sort of replying, right? Well, look, crime didn't go up. That's not why the Safety Act got going. There are these big ideas about why the Safety Act gets going, but it's a reply, right? And so this is a little bit of a reply to the critics of the Safety Act when they respond. And again, I sound too formal. The reply to the critics of the Safety Act is the judge made the decision that she made. Why were you comfortable with her saying 2 years ago, $100,000, I don't know whether the guy has money, next case? That's my problem. The association that criticized the Safety Act on that DeKalb case, I don't recall issuing a press release about the horror of somebody posting cash and then hurting somebody else, or from their perspective, just being released. So if they've never done a press release about cash, but they're going to do a press release on this, I think that's unfair.
Yeah, no. I'll add my small defense attorney take here. It is rather horrifying that we are making decisions about whether somebody should be detained solely based upon the title of the charge. And I do think that we, even the very conservative Rehnquist court, right, talked about how pretrial incarceration is supposed to be the exception to the rule. And oftentimes we make these decisions or we make these perceptions about kind of what should happen in a case based upon the idea that pretrial incarceration, before any evidence has come in, should be the punishment to something that we agreed that has happened, and that there should be no judge and jury about that. We should make that decision now. So coming from an office where thousands and thousands and thousands of people are accused of offenses and then found not guilty by their peers or by a judge, I just do want to push back on the prop. There's a small pause that this idea that, of course, somebody should be detained, look what they were accused, is one of the reasons why we got to a point with mass incarceration in our country. And I just love that we have a system now where we can have real discussions about detention outside of, oh, you're charged with a certain offense, you should be detained. I mean, that's kind of the market-based analysis that we had before. Not to comment on any specific case, and I know that people will have different ideas about it. I think there's also something to be said about when we talk about these conversations as if that there is one group that is victim and one group that is perpetrator. And I would just say that I think that our office directly represents a lot of victims of crime and of harm. And sometimes when we're talking about these conversations, there seems to be this, there's a bad guy and there's a good guy. And I love the pieces that kind of explore how an accused person got to the place that they are. Not to say that that is a full justification for accusations, but there's typically a more full story.
Maybe more a question on process than theory, but as we're talking about staffing levels and funding levels at some of the different counties, so as county boards and state legislators consider those questions of staffing and funding, what's happening over the weekend? For example, it used to be that DUIs or promiscuity or domestic instances would bail out immediately. Say someone gets arrested at 3 o'clock on a Friday afternoon on Memorial Day weekend, how long are they there before they can actually get a detention hearing? And should courts, are they going to have to shift? Are they shifting to work on the weekends?
Luckily, Cook County has had kind of bond court now, initial appearance in detention court on the weekends. And that is something that, the Pretrial Fairness Act did not create the need for there to be decisions 7 days a week. You're right that there's obviously a more detailed decision-making process. So we've had to, I think, some offices have asked for more support. We've also had to kind of reallocate how we provide that support, how we, create our, how we align our resources. But there's been a precedent, and there's been weekend and detention and holiday bond court, at least in Cook County for quite some time, and in many other counties.
So for my county, we do not have 24-hour, 7-day-a-week court. We do detention hearings on Monday, Wednesdays, and Fridays. So the scenario where someone got arrested Friday afternoon, will they stay in jail until Monday? Most likely not. Our state's attorneys they have set up with our police departments that they always have a state's attorney or assistant state's attorney on call. The police are to call them and get the word as to whether or not to bring them to the jail to basically have them held pending a petition for detention to be filed. So those calls are being made, whereas before that was, again, the police discretion on who they're bringing to the jail, when they're bringing to the jail. Now, before they bring someone over, the calls are made to the state's attorney's office. And the assistant state's attorneys, now that they have guidance on, what the judge is detaining on, what he's not detaining on, we are not seeing people being held outside of our shootings. If you shoot somebody on Friday, you're going to be held till Monday. I mean, that's kind of a given. But that's pretty much where we are. with that, I would greatly appreciate if we had a Sunday afternoon setting or a Saturday afternoon setting. I'm sure my assistants would love to come in and cover that. But as it's working now, that's kind of our schedule for it. There's always going to be a one-off that gets arrested and something like that would have to happen. We haven't met that yet. We're not there.
So I'm going to wrap us up there. Thank you. Can you all help me thank our lovely panelists for sharing their insightful perspectives?